Welcome to The Explainer. Today, we're jumping right into a pretty high-stakes legal battle that's really shaking up the real estate world. We're talking about a fight between real estate agents and their own very powerful national organization. So why on earth are real estate agents suing their own organization? I mean, it sounds a little strange, right? But that's the absolute core of a major court ruling that just came down in Louisiana. A group of agents decided to go head-to-head with the industry giant, the National Association of Realtors. You probably know them as NAR.
Okay, so the big headline here is that a lawsuit just got dismissed. A federal judge basically threw out a major case filed by a group of brokers and agents against NAR. And, this is a really big deal, so let's break down exactly what happened.
And we're not talking about some small claims court thing here. No, this was a full-on federal case. It was brought by a few specific brokers and agents, Carla De Young, Carlos Alvarez, Tammy Jo Williams, and Darlene Curry. And get this, they weren't just going after the national organization, NAR. They were also targeting the local realtor associations right there in Louisiana. So you're probably wondering, what's all the fuss about? What rule could possibly be so controversial that it leads to a federal lawsuit? Well, it all comes down to one thing, something the industry calls the three-way agreement. And believe me, this rule is a huge part of how real estate agents do their job every single day in the U.S.
Okay, so here's the deal with this three-way agreement. If you're a real estate agent, you absolutely need access to the multiple listing service, the MLS. I mean, that's the database with all the homes for sale. It's essential. But to get that access, you're forced to join 3 different organizations, your local one, your state one, and the national one.
Let me put it another way. Imagine you want to go to the gym down the street from your house. But to get a membership there, they tell you that you also have to join a statewide fitness club and a national gym association. You'd probably think that's kind of crazy, right? Well, that's pretty much the core of the complaint here. The agents who sued said this whole 3-step process is just unfair and way too restrictive.
So that's the setup. Now let's head into the courtroom, because this is where things get really interesting. Both sides came out swinging with some powerful arguments.
Okay, so check this out. It's fascinating how both sides look at the exact same rule and see something completely different. On one side, you've got the agents saying, hey, this is illegal. They argued it violates federal laws like the Sherman Antitrust Act. They claimed it's an illegal tying arrangement, forcing them to pay for 3 memberships just to get the one thing they need, the MLS. But then NAR comes back and says, whoa, not at all. They argue the system is actually good for competition, and most importantly, it's good for consumers because it creates fair and stable local markets. All right, so you've heard both sides. The arguments were made, and the decision fell to a Louisiana District Court judge, Shelley D. Dick. So, what was the verdict?
And here's the bottom line. The judge permanently dismissed the biggest, most serious federal claims. We're talking about the Antitrust and the Fair Housing Act allegations. Just gone. And that dismissal applied to NAR and the local associations. This was a huge win for them. Now, the judge did kind of leave a little crack in the door for state-level claims and gave the plaintiffs 21 days to maybe try again against one person. But the main event, the federal case, yeah, that's pretty much done.
You can bet NAR didn't waste any time. The reaction was super quick. A spokesperson put out a statement right away, basically celebrating the win and doubling down on their whole argument. They're sticking to their guns. These rules, they say, are good for business and even better for the consumer.
But, and this is really important, you have to zoom out a little bit. This Louisiana lawsuit isn't some isolated incident happening in a vacuum. Nope, it's just one fight on one battlefield in a much, much bigger war being fought all across the country over NAR's rules and how it's structured.
And when you look at that bigger picture, you can see a pattern. NAR has been racking up wins defending this very rule in other states. They've already won similar cases in Illinois, Pennsylvania, and Texas. But the fight is definitely not over. There are still cases just like this one pending in places like Michigan and Maryland. So this whole issue is far, far from settled.
And this quote from NAR CEO, Nikia Wright, from back in November really tells you everything you need to know about their mindset. She's framing this whole thing not as a set of restrictive rules, but as a vital ecosystem. The idea is that all 3 levels, the local, the state, and the national, are all working together, in harmony, to make the whole market work.
So this all brings us to one big final question, doesn't it? On one side, you've got this incredibly powerful organization, NAR, that keeps winning in court, saying its rules are essential for a stable market that's good for you, the consumer. But on the other side, you've got this growing wave of agents who are challenging the very foundation of how things have always been done. So what is it?
Is this membership model a critical pillar holding everything up, or is it just an outdated rule that's about to be completely disrupted? Honestly, that is the multi-billion-dollar question the entire real estate industry is trying to figure out right now.